What is the difference between a corporation and a company? The terms corporation and company all too often are interchanged when speaking of everyday corporate business activities, such that even in legal documents drafted by highly experienced business lawyers, you will see references being made to both corporations and companies, and oftentimes in the very same legal agreement. Nevertheless, there are distinctions as between a corporation and a company that one should take note of, and it isn't found in a basic internet search on the topic, which provides, in my professional estimation, baseless distinctions as to the differences between corporations and companies. Instead, one should be looking at the legislation of the jurisdiction within which one is operating in to ascertain what distinguishes a company versus a corporation, as well as the case law arising from that jurisdiction's courts. It is through such a review that one can properly understand the legal distinctions and thereafter use the appropriate terminology when making reference to a particular business entity. In both the United States of America and Canada, the appropriate statutory reference for use with for-profit corporate business entities is that of a corporation. The governing legislation refers to them as corporations, with there being specific carve-outs that are themselves corporations but have unique characteristics and use company as part of their designated identifier, although not merely companies in the sense that they should be referenced to as a company without the other associated wording. As such, one has limited liability companies or LLCs, unlimited liabilities companies or ULCs, and trust companies, where they are permitted by the governing statute and having distinct characteristics from a regular corporation. They must maintain those distinct characteristics, otherwise they will lose their statutory characterization as a limited liability company, unlimited liability company, or trust company. Furthermore, in most Canadian jurisdictions there exists Companies Act legislation, which serves to create not-for-profit companies and charitable associations. Here again, from a legal standpoint, using company by itself to make reference to this particular form of corporate entity is not necessarily appropriate, given that it discounts the unique legal attributes that need to be ascribed to not-for-profit companies. Meanwhile, in the United States of America, most nonprofits are incorporated as non-profit corporations, such that their legislation does not make reference to company in a non-profit entity, but instead to a non-profit corporation. So why the confusion? Most likely because the United Kingdom uses the term company as opposed to corporation, with their Companies Act being the statutory basis upon which for-profit business is undertaken, and corporate entities are formed and are ascribed the name company, which in turn is used in other jurisdictions, even though it is necessarily appropriate for use only in jurisdictions such as United Kingdom, which has a Companies Act that provides for for-profit companies and the name company by itself. Thus, from a legal standpoint, the more appropriate term would be a corporation, such that use of the term, unless part of a defined term, such as a limited liability company or trust company, should be limited, even though many people would like to make it interchangeable. The word company is not necessarily the best choice of word selection, when corporation is more appropriate as it tracks the jurisdictions governing legislation. That is, unless you are in a jurisdiction such as the United Kingdom, where company is the appropriate term for referring to a corporate entity. Thank you.